I'm Drew Stevenson, and this is a video for my professional responsibility class about ABA Model Rule 1.9, which is conflicts of interest with former clients whom you no longer represent. This is the second video in the series about this rule. This is a complicated rule. It has multiple sections, and so I decided to break the videos up into shorter ones. And you should watch the first video before this because it goes through the provisions of sections A, B, and C. In this video, I'm going to be talking just about comments 2 and 3 to the rule, which include a lot of hypothetical scenarios that I turn into hypothetical or multiple choice questions on my exam, and that I think are good candidates even to appear as multiple choice questions on the MPRE. So let's dive in. First, comment 2 notes that the scope of a matter for deciding whether we have a conflict depends on the facts of a specific situation or transaction. In other words, it depends, and the lawyer's involvement in a matter can also be a question of degree. So both are ambiguous. In practice, this means that we're going to have a lot of litigation over disqualification motions about this rule, because there's plenty to argue about whether the scope of the previous matter you handled for the former client, who let's say is now trying to have you disqualified, is the same, right? It overlaps enough with the new matter. And some scope is sometimes a little hard to define or in the eye of the beholder, and it's certainly going to vary from representation to representation. So there may be a certain client where you handled a very discrete part of a transaction or litigation that they had pending, and there could be another client where you were involved from beginning to end, and even in dealing with tying up loose ends in the aftermath. And then the lawyer's degree of involvement is going to be an issue, and we're going to clarify both of these things a little bit. So on the second point, when a lawyer was directly involved in a specific transaction, subsequent representation of other clients with materially adverse interests in that transaction clearly is prohibited. So if you were the lawyer who handled a client's matter from beginning to end, then clearly you were directly involved. Or maybe you were involved, were involved in a meeting with the client, you know some confidential information, and so forth. Well, that's going to be the clear scenario. So even though in practice this can be a matter of degree, if you get a multiple choice question on my exam or the MPRE, they're going to have some facts describing the situation to kind of tip you off that the lawyer was directly involved or not directly involved. And then here's on the other hand. So if you just recurrently handled a type of problem for a former client, you're not precluded from later representing another client in a factually distinct problem of that type, even though the subsequent representation involves a position adverse to the prior client. So remember, you have a prior client who the representation has ended, you no longer represent them. A new client wants to sue them or be the other party in a transaction. If it's completely unrelated factually, then there's usually no problem with that. But if it does overlap, then you would be precluded from the new representation or would have to at least get the former client's informed consent confirmed in writing. Now, the fact that you did contract work for a few years for one client doesn't mean that you can't represent a party who is either the other party in negotiating a contract and drafting a contract, or a party who's litigating against them for a breach of contract if it's not a contract you worked on. Or the same is true if you're a patent lawyer and you did various types of patent work for a certain client, and you no longer represent them years later. You have another client who is the opposing party in a patent infringement case. Well, if it's not a patent that you worked on at all, the fact that you did some patent work for the other side does not trigger the application of 1.9. Now, this is a very important point. If you don't get anything else out of this video, please pay attention to this slide. The underlying question is whether the lawyer was so involved in the matter that the subsequent representation can be justly regarded as a changing of sides in the matter in question. So obviously you can't start out litigation representing the plaintiff, and by the end of the case, you're representing the defendant. You've switched sides. That's exactly the type of thing that 1.9 is supposed to prevent. If you don't remember anything else about 1.9, keep in mind it prevents you from changing sides in the same litigation or the same transaction while it's still pending. Or if you represent one party at trial, you can't represent the opposing party on appeal. If you represent one party on appeal and the appellate court remands it for a new trial, you can't switch sides for the remand. So keep that in mind. If you get a hypothetical or a multiple choice question that says, or a bar exam MPT question, and ask yourself if it seems like the lawyer is changing sides in the same matter. Okay, so what counts as a substantially related matter? Obviously, the word substantially gives a lot of leeway or leaves a lot of uncertainty about this. And so here's a partial definition. The ABA does have a recent ethics opinion that fleshes this out a little bit more, but for purposes of this video, let's just focus on the comment. Matters are substantially related if they involve the same transaction or legal dispute, or there otherwise is a substantial risk that confidential information, as would normally have been obtained in the prior representation, would materially advance the client's position in the subsequent matter. So notice that there's two prongs here. One is it's basically kind of the same incident. So let's say that one case involved a prosecution, criminal charges over a wrongful death, like negligent homicide. And the subsequent one is a civil action for wrongful death over the same person dying. If that would be substantially related, it's the same incident that generated the litigation. The second is about confidential information, and the comments give a few helpful illustrations or hypotheticals, again, that I think you're likely to see as test questions at some point. So, for example, a lawyer who has represented a business person and learned extensive private financial information about that person may not then represent that person's spouse in seeking a divorce. Now notice, even though could be different areas of law, so you represented a wealthy business owner and entrepreneur in a lot of just their business matters and financial matters. But in the course of that, you know that they have millions of dollars stashed away in offshore bank accounts, right? Well, even though the divorce is a family law, it's completely unrelated to the type of representation you provided for the former client. Your kind of insider knowledge about the client's financial situation gives a strategic advantage to the spouse who's seeking a division of the marital property or things like that. So keep that in mind, that the confidential information, if it's relevant, can also trigger 1.9, even if it's not a related matter otherwise. Here's another example that, again, very easy to turn into a test question. A lawyer who has previously represented a client in securing environmental permits to build a shopping center would be precluded from representing neighbors seeking to oppose rezoning of the property based on environmental considerations. So even though it's a different type of legal work, one, you're representing a developer who wants to turn a certain parcel of land, a vacant lot, into a shopping center, well, that involves getting a lot of permits and approvals from state and sometimes federal agencies and local government officials, municipal authorities, and so forth. And some of that is going to be related to pollution, like the water drainage from the park when it in storms from the parking lot and so forth, or noise or air pollution and so on generated by this. So let's say after that, and you no longer represent that client, the neighbors are still trying to stop construction with zoning based on very similar environmental concerns. Well, the information you have from the prior representation is too relevant to the new case, even though one was getting permits and the other is opposing rezoning of the property. On the other hand, here's an example where it would be okay. The lawyer would not be precluded on grounds of substantial relationship from defending a tenant of the completed shopping center in resisting eviction for non-payment of rent. And so let's say the developer completes the shopping center from our previous slide and fills it up with little shops and businesses. and a few years later is evicting one of them for not paying rent. Well, that poses very different legal issues, and it's unlikely that any of the information that you learn in getting environmental permits for the construction are going to be relevant for whether this tenant is current on their rent and whether the landlord is following proper eviction procedures and so forth. It's distinct enough that you could provide representation to one of the tenants that your former client is trying to evict. Keep in mind that information acquired in a prior representation may have been rendered obsolete by the passage of time. So, for example, you represent a business, and by the time that you are representing someone else against that former client, there's been a complete turnover in their workforce or in their management, right? And it may be that the litigation really relates to certain decision makers or a certain problem supervisor, something like that, that was relevant then and is not really relevant because that person doesn't even work there anymore, the relevant person in question. So that's not going to be relevant. Information can become stale. Or it could be that you knew information that was confidential at the time and now it's public knowledge. Now, what about general versus specific knowledge? General knowledge of a client's corporate policies and practices ordinarily will not preclude a subsequent representation, but knowledge of specific facts gained in a prior representation that are relevant to the matter in question ordinarily will preclude such a representation. So almost all entities have some sort of employee manual or some HR manuals and things like that they follow, and those are pretty standardized and wouldn't take you much investigation to learn about. So that's general information and probably not prejudicial information in the new representation. It's not confidential information. And the same could be true if this is an industry or a type of business where their annual revenue fluctuates a lot throughout the year. So there's certain businesses that make almost all of their money in the holiday season, on like some retailers on their sales, and don't make very much during the summer or the spring. There's other businesses that are the exact opposite. So if it's selling houses or wedding venues, right, those peak at certain times of the year and are not in use as much other times of the year. So that's general knowledge. But let's talk about a couple specific fact scenarios. I mentioned the situation that when you represented the former client, there was one problem supervisor or mid-level manager that people were always complaining about. Their subordinates were always complaining about harassment and mistreatment and abusive behavior. And now you have a new case that's from a former employee against the company for harassment. Well, if you know who the bad apples are at the company, that's a specific fact. Similarly, a lot of entities have a few people who work there who really exert a lot of influence or control. And sometimes it doesn't always align with their title. So obviously the president or CEO has a lot of authority in the company, but sometimes there's another person that you wouldn't expect who actually gets to weigh in on things because the president really trusts them or respects them or has to listen to them. Or there could be different people on the board who basically always get their way or have veto power or the final say on decisions. That's a specific fact that could be really strategic for the lawyer on the other side to know who really controls the decisions and who is sort of has a title, but they're a ceremonial figurehead. So they have a title but don't really exert authority. That's a very specific fact that could be relevant for 1.9. Now, let's say a former client is upset that you're the lawyer for the other side in litigation, and they're trying to have you disqualified, usually through a pretrial motion for disqualification. What do they have to reveal? Well, you may be wondering, like, what information do they think is relevant for this new matter that could be really useful and strategic? And we don't want to discourage them from pursuing their rights. So a former client is not required to reveal confidential information learned by the lawyer in order to establish a substantial risk that the lawyer has confidential information to use in the subsequent matter. In other words, you can't use this, their disqualification motion, to go on a fishing expedition and get them to divulge something that you wouldn't have otherwise known, or explain why they think certain facts and details are relevant for the new matter. Instead, the judge can make inferences based on the type of legal work you did. So the nature of the services that the lawyer provided to the former client, and then the type of information that a lawyer would ordinarily learn while providing such services. So even if you don't remember the information, you didn't keep your notes from the representation, or for whatever reason you didn't ever find out that crucial confidential fact, a judge can infer it just from the type of representation you provided, that lawyers often would, under those circumstances, have the confidential information. So this wraps up this video. Don't give up on me. I have more to come, kind of fleshing out 1.9 and some more of its provisions in the comments.